Okay. Who wants to start? Shouldn't be a lot of different changes. I mean,
There are, I think we're perhaps changing some names here and there,
right.
but there is one, and of course since these pages are not numbered, and here's the page, if I can put it up on.
Okay. Well,
Yes, let me do it. Yes. The more I was thinking about this, since we don't have counts 8 and 9, that paragraph about Mr. Quincy and Finley.
oh yeah. I thought I'd mark that out anyway.
I think it should probably say, I think we should just substitute, if I may I sit, Your Honor, or I can stand if you want.
Either way, it doesn't matter.
First I struck it like Mr. Moore, but then reading it again, I think it would be more applicable and understanding if we just say this is the case. In this case, it is a question for the jury to determine whether the witness, Jaborian Tip McKenzie, was an accomplice in this alleged crime. Counts.
Excuse me, just back up. Let's talk about the Quincy and Finley as being for the jury determination. And I went the other way. I was starting to write Joseph Quincy was an accomplice, and then the more I thought about it, it's really no, because he's not because he's not related to those counts. But I think that it should stay in that Jaborian McKenzie is an accomplice as a matter of law, correct, and not for the jury to determine.
Correct. So you have to put in McKenzie in that paragraph and take out counts 8 and 9, because it goes down further and says that the defendant cannot be convicted upon the uncorroborated testimony of this witness, and that's not in the other paragraphs.
Correct. If we add that, I think I'm
yes,
fine.
This paragraph comes out in its entirety. And we would also say that last paragraph, because we were trying Mr. Vandenburg the last time, his name wasn't in there, but the indictment also charges Brandon E. Banks, Brandon Vandenburg, and Jaborian McKenzie. Their charges have been severed. Right. And you're not to consider that. The fact it's opposed to them, the word them, I submit should be that. Because what you're telling them is they're not to consider the severance. Right. They obviously are to consider what's been talked about the other.
It should be that, and Vandenberg's name should be added to the other two. All right. Anything else?
Well, not on that page. I'll turn it over to somebody else.
Your Honor, is the charge on inference of concealment or destruction of evidence appropriate in this case?
I don't think so.
I don't think so either.
I haven't seen it yet.
Let me
see.
They're not. These pages aren't numbered, Your Honor, but it's maybe two
I'm not
pages.
so sure about that.
Again, we're dealing with conspiracy, aiding and abetting, so the act of one is the act of all.
Right. Yeah, and I think about the testimony with regard to the bathroom. So it actually should stay in.
Even if Mr. Batey was not in the bathroom, not a part of that conversation, had nothing to do with that. There's been no testimony that he had knowledge of that conversation. I think that's just going to confuse jury because there's been no allegation that he destroyed or concealed any evidence.
That came out in the testimony, and it's part of the trial testimony.
Also, remember in his text about deleted videos, have they been deleted yet? He's obviously trying to destroy the videos in this particular case. And obviously the cell phones were destroyed and all kinds of stuff. He was obviously into the loop, meeting with Mr. Vandenburg and all of them trying to cover it up. So
There's no evidence of that, though. None. That he had anything to do with Mr. Vandenberg's attempts to try to get Mr. Quinzio's cell phone. And text messages. I just think the inference of that is it's just not a part of the proof here today. If it's included, I'm afraid they're going to believe they missed something.
Well, I'm going to leave it in for now. I will take a closer look at it and make a determination, but I'm going to leave it in for now.
Yes, Your Honor.
Anything else? With respect to the expert testimony, I substituted Dr. Walker's name for Dr. Lipton.
Yes.
Because of his opinion was based upon what he was told, just as in Dr. Walker's case. So that should be reflected in there, is it not, Mrs. Clark? Okay. Anything else?
I'm asking Mr. Moore.
And you're free over the evening to, review these charges, and tomorrow morning, if you would provide any requested changes tomorrow morning, not during closing argument. Ms. Clark does not like it when you wait until closing argument to offer changes in the charge.
Your Honor, I was asking, and maybe you can think about this one, or Mr. Moore can think about this one, and the number one here, that the defendant had unlawful sexual penetration of the alleged victim, and then the or is...
That's just part of the pattern instruction.
It's certainly not applicable and could be confused. It's surplus is what I would say, Your Honor.
Okay.
And maybe Mr. Moore can think about that tonight.
No, I don't think it matters really one way or the other. It'd be the same thing of taking out.
Right. That did not happen, and at least there was no testimony with respect to that happening.
It's just a question, I think, just how much excising needs to be done, if
Okay.
any.
Well, I'll review the charge as well myself, as I normally do, and see if anything needs to be taken out or added, for that matter.
Your Honor, we would also request the motion in limine that we filed and argued, I believe, Monday morning about referencing the element in the prosecution of that offense. I know we talked about it.
Right, and I reviewed the case law as well as the statute, and 3911-503, I believe, is the statute, and it specifically spoke to that. So with regard to recklessness, and as I said back then, I was under the belief that it was correct, the instruction, as I am today, because I said that I would read the cases and the statute, and I did, and I became more convinced that it was the proper instruction.
So Your Honor is ruling that you will not include the specific language that's in this?
As to that element?
Yes, sir.
Right, no.
Okay.
No.
Just need that for the record. Thank you.
I think it'd also be appropriate this time, maybe to state that I think it would be inappropriate, even unethical, to argue jury nullification and to tell a jury that it can be a defense to aggravated rape by a principal offender, the intoxication. I just think that needs to be made clear that it would be an improper argument.
It should not be argued, and if it is, please object. I'll have them strike it. I mean, it's not a defense. It's only a defense to the word skips. Criminal responsibility and aggravated sexual battery.
And in that line of thought, Your Honor, tell me, you explicitly stated if jury nullification is argued that you want the state to object. The state has a tendency to object during closing arguments. My experience has always been that you refrain from doing that, talk about it, and then Your Honor will take it up. Would you tell me how you do that? Last year, I know in closing argument, Ms. Norman argued, put on the board the wrong law. And I just let it go because...
Each side has the right to object during closing.
Okay.
Absolutely.
Okay. All right, I just need to know your custom and practice, so we'll...
Sometimes they do, sometimes they don't.
Yes, Your Honor.
Your Honor, please, just because I would never want to put up the wrong law. What is the law that you're stating that
I can go back in the closing.
Please do so and let me know. I don't want to do that, and I want to confirm that it was incorrect.
It was.
If there is anything else, please bring it to my attention tomorrow morning. I'll be happy to take it up. Everybody have a good evening. See you tomorrow. We will finish up tomorrow.
I thought we were going to address a few issues. We probably need to address one in the back, maybe not on the record. Not supposed to be on the board. Just about things that might come up tomorrow.
Okay.
Take a little time if we can kind of get
Well,
straight.
yes, we can do that now. Sure. We could go back and address those issues. All right. Yes.
All rise. We'll do an adjournment. 9 a.m. tomorrow morning.